hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator.
All right, welcome back to the next episode of the BC Law Just Law podcast. We're joined today by Professor Farbman and Ali Shafi, who's a 1L, to talk about something that's been in the news pretty heavily lately in the city of Boston, which has been Mayor Michelle Wu recently, and a couple of hot topics. Number one, the North End restaurant owners. This has been sort of a controversy in the last month or so with respect to outdoor dining. North End restaurant owners being fined to continue to do outdoor dining. This is something that during COVID has been pretty popular among a lot of restaurants who've suffered pretty mightily, and so of course the fine has engendered some controversy, as well as another issue, an ordinance that has curtailed protests. Of course, Mayor Wu, particularly early, in her term at her house, was somebody who was at the scene of many protests, people coming early in the morning and making their unpleasantries pretty clear. And we kind of want to talk about the legal and policy side of some of those issues. So Professor Farbman's joining us today to talk about that. Professor Farbman joined the BC Law faculty as an assistant professor of law in 2017. He teaches and writes in the areas of local government law, legal history, constitutional law, the legal profession, civil rights, and property. Professor Farbman, how are you?
Doing well.
Great.
Glad to be here.
Yeah, thank you. So we just want to start with this outdoor dining situation. So as I understand it, you've had during COVID, people had a social distance, you had to spread out. A lot of these restaurants are very small. They've really taken a hit financially, and so a solution for the last couple of years has been to let people have their tables outside. Extend into the sidewalk and into the street to be able to make up lost revenue. That's been something that's been popular for diners. It's been popular for restaurant owners, obviously. But according to the mayor, it's been pretty unpopular among people who live in the North End, and so you've had this policy of having to pay a fee to continue to do that. It's been controversial. What can you tell us about that? Because it seems a lot more complicated than the things you hear hurled when you're walking down Hanover Street.
Yeah, sure. So there's a couple of things to say. I think maybe it's important to start off with we take for granted certain things that the state provides, and we think of them as things that are free, but in fact they're not. So, for instance, we frequently think of streets as a thing we own, that they're a thing that we have a right to. Sidewalks are a thing we own, that we have a right to. So, in my neighborhood, they just built a bike lane, and there's been a lot of protest about you're taking our streets from us, right? But that's not actually how it works, right? Streets are actually a subsidy for cars. Sidewalks are a way of helping people move through space, but they're a thing paid for by the city. And so all of those things are public goods, right? And so the question for any local government is going to be, who do we let use the public goods and how? Well, so we have driver's licenses, right? We have parking permits, and there's a whole network of ways in which we restrict or regulate access to these public goods, right? And so, as I understand what's going on in the North End, it's basically an application of a licensing regime. So the city of Boston says, here are the conditions under which you can use our sidewalks, use our streets, right? And that's always true. Here are the conditions under which you can use our sidewalks, use our streets. Outdoor dining for a long time was they said, because they wanted to, for the reasons you suggest, they wanted to make it easier for the restaurants to survive. They said, you do outdoor dining, we want you to use our streets this way. The problem is it has costs, right? And so you mentioned the costs of the local residents complaining. I think that's a big piece of it. I think you do have a real clash here between the businesses and the local residents, and that's in the North End. That's always been a clash, right? It's always been a clash. Right. But I think more broadly, you have there's just a cost to outdoor dining, which is a cost in sanitation, a cost in rodent prevention. We have rodent infestation in the city right now, and it's especially bad around restaurants. And so there are costs to the city to maintaining the public spaces. So the sidewalks are not. The restaurants don't own the sidewalks. The restaurants don't own the street. Those are public goods, and the city is restricting access to those public goods in the ways that it's just completely normal local government behavior to say, when you want to use something, you have to pay for it, or here are the conditions under which you can use it. So in that legal sense, it's uncontroversial, right? This is an application of a licensing regime.
So going to the fine, there's this sort of $7,500 fine, which it's not cheap. But is this a situation where the city is trying to sort of use that fine to pay for some of those expenses that you named, or is this more of a sanction, more of a slap on the wrist to try to disincentivize North End restaurant owners from doing something that seems like creates some issues, like you were referring to?
So as I understand it, it is, and this is we're actually in a second iteration of this. There was initially the $7,500. I'm not sure fine. I think fee was the term they used.
Potato.
I'm not sure that's potato. If you truly believe that all money is the same, I think lots of people would say it's different if you charge me a fee for access to something versus you punish me for doing something. I mean, there's a lot of law that built on that distinction, right? So, but let's consider it. I think a fee is the way that I would understand it, because ultimately we're talking about the use of a public good and fee for the use of public good. As I understand it, in the second iteration that's gone back, there was a conversation between some of the stakeholders in the restaurants, some community members, and they've adjusted it now so that there's you can pay month by month if you want, installments. And as I understand it, and I'm not privy. I wasn't privy to those conversations, right? This is all sort of secondhand. As I understand it, that compromise was actually between the residents and the restaurant owners to say, the residents said, well, we want you to invest. We want the city to invest these things. And the city said, we can't invest those things unless we get the following fees. And then they came to this solution, which both includes the installment plan, but also a hardship fee for the restaurants that actually are having a hard time. Because the reality is, at this point in the pandemic, what's going on this summer is that those restaurants are doubling their capacity.
Right.
Yeah.
They're not actually losing. In past years, they hadn't been able to fill the restaurants. Now, with the restrictions off, the restaurants are doubling their capacity, which means, restaurants run at scale. If they're able to make more profit, they're doubling their capacity. And again, they're doing it using public goods, using the sidewalk, using the street. Now, is it I should say, I'm actually someone who really supports outdoor dining. I love going to Europe, and I love in those spaces where that's prioritized. But that's all when you have a patio in Europe, you're paying the city for your patio. There's it's understood that you're actually getting access to a public good, and and the city is prioritizing it. They're making pedestrian streets, but that's expensive. If you wanted to make Hanover a pedestrian street or a one-way street as they're proposing, that requires adjustments to the other infrastructure around because people have created a reality around the infrastructure as it is.
Right. I have one other question that Ali, if you want to ask about, some of the negative sort of economic impacts, that'd be good. So in terms of this lawsuit, you had restaurant owners threatening to sue. We're going to, so in terms of the legal issues, the property law issues, what would you sue for? It sounds like the city has more or less an absolute right to control what's going on with those sidewalks. What kind of legal issues could these restaurant owners try to use, if any?
So as I understand it, the ordinance was written relatively carefully. So it would be true if they were charging you for outdoor use on private property. That would be a problem, right? As I understand it, that's not that it's only that the fee only applies to the use of the sidewalks and the use of the street. So that's one thing. So as I understand it, that issue is not there. So I'm not sure there's a property issue there. I've heard some equal protection arguments mooted. There again, I'm just not sure that has any real play. People have talked about it as punishment because the North End residents or the North End restaurant folks are not Mayor Wu's political allies.
Yeah.
I suppose you might be able to make some argument there. I honestly, that doesn't feel like what's going on here.
Yeah.
I feel like there's a particular problem on Hanover Street,
yeah,
which is that it's very crowded and there are costs to its crowdedness. Yeah. And that's not the sort of thing that raises an equal protection problem either under the Massachusetts or federal constitution.
So just following up on that briefly, so I have heard these conversations about, is there an equal protection issue? So looking at the con law aspect of this, on the one hand, as I remember, you need to be able to show that a protected class is not being treated the same way. I don't know that, owning a restaurant in the North End is protected class. I've also heard, these are, all Italian Americans. I don't know how that plays. And, at the same time, I think the political point, look, these are, blue collar mom and pop restaurants. These are not really Mayor Wu's constituency, I think, for the most part. Are there any wind in the sails of the equal protection case, or does it seem like you don't really have the elements?
I don't think so. I think it's not irrational. Yeah. If you are someone who feels as if you're not Mayor Wu's political ally, and that she is treating you differently than she would be treating other folks, it's not irrational to feel as if there's some inequality there. It's not even impossible to imagine that the political calculus around this is, she feels like the residents of the North End are more sympathetic to her. That's how politics works, right? We see this all the time. Is there an actual constitutional claim there? No. I mean, certainly being a restaurant owner is not a protected class. If it were just malicious, if there were no other reason for doing it, if it were just malice or just animus, that could be a problem. If it were true that you could show that she was doing it because they were Italian, because they were Italian American, that could be a problem. It's not the case. I also just want one other point. The narrative that these restaurant owners are blue collar mom and pop. Now, some of them are, right? It's also true that some of these restaurants are extremely profitable enterprises. Some of these people own a lot of restaurants. Some of these people own a lot of restaurants. They're making a lot of money. Even if they are, in fact, mom and pop businesses, they're actually extremely profitable mom and pop businesses. They're putting people in the top 1% of earners. It's not the case. We're not talking about, your scrappy little businesses. These are restaurants on one of the most valuable pieces of restaurant real estate in the country. Right. And most of the restaurant owners, if you ask them, in private, would say, "Yeah, we got the $7,500 to pay. We just don't want to." Right. And now the new ordinance or the new regulation seems to account for those who can't. Right. So I think that narrative that fits into a kind of narrative about the elite versus the mom and pop. And the problem with that is that has a racialized tinge also, which is that these are all white small business owners who are actually making quite a lot of money and labeling themselves as blue collar and oppressed and as Mayor Wu's constituency as the sort of other, and Mayor Wu's constituency is much more diverse, and she herself is not white. I just think we got to be careful about how we do those labels, how we think about those labels, and who's claiming what label and who's claiming to be oppressed and how, because I think there's some of that going under the surface here as well.
So from a sort of political game, less than a constitutional one, do you think that, if the North End was full of these large national chains, would this ordinance look any differently? Like if it was just Tate's down the line, do you think that this ordinance would look any different?
So it's an interesting question. I think, I don't know. Again, I'm not an expert in the internal workings of the Boston City Council that are at play here. So there could definitely be dynamics in the North End community that are driving this, that are meaning that this is harsher than it would be in other contexts. My first intuition is that the fine would be more, or the fee would be more. I should use my own terms. The fee would be more because Tate could pay more, right? That, $7,500 is actually not that much, for a large firm, a large company that has like a bigger sort of like war chest, right? So, if I were the mayor and I was trying to get more money for all the services that I wanted, and it was all au bon pass, as Harvard Square used to be, I would charge him more because I could get more out of him, right? So it could go in either direction, right? It may be that the mayor's office is completely captured by Tate, in which case, there's no fees because they're just completely captured by Tate. I doubt that that's true, right? And I just think you could go in either direction, right?
Do you think this is applicable to other neighborhoods in the city, because rat problems, littering problems, that noise problems, that exists in all outdoor dining spaces?
Yeah, it seems like the North End's being singled out.
Well, so the North End. So you could argue that the North End is being signaled out because it's the North End, or you could say the North End has a unique set of circumstances. So the North End streets are narrower than any other streets in the city, and the density of restaurants on Hanover Street is higher than any other place in the city. So we have to ask the question: if we're just talking about collecting fees that are required to deal with the infrastructure problems that we're dealing with, the North End has a particular set of circumstances that justify differential treatment. I mean, so the point is, if you look at the neighborhoods in Boston, there's differential treatment everywhere, right? There's some places they collect trash twice a week. Some places they tow you if you're parked there. Some places they don't. Go to Roslindale. The way that the public space is regulated in Roslindale is very different than the way the public space is regulated in Alston, the way the public space is regulated in the Back Bay, right? These are really different places with different needs, and the city, by and large, has always regulated differently in those places because of the different needs. So because of that, that's the most obvious explanation for what's going on here, is a particular set of circumstances with a particular response. Now, is that ruling out the fact that somebody in the mayor's office has it in for the North End? No, but I just don't think that that's not the first and most obvious answer to what's going on here.
My last question I want to ask about dining, and then I want to move on to this protest issue. The $7,500 figure, I guess, when it comes to a city enacting a fee for something like this, how do they arrive at $7,500? Is there a legal requirement that you need to be able to show that that's like reasonable? Is there some economics that need to go on to figure, okay, if we're going to have to pay for sanitation, or we're going to have to pay to the upkeep and cleaning this area, et cetera? How do you arrive at that? And just from a legal perspective, is there a requirement that fine, that amount that they arrive at is reasonable, and you have to be able to demonstrate that, or is that not the case?
Well, I mean, as with any regulation, is going to have to meet sort of a basic rationality threshold, that you can come up with a reason for doing it. It's just a very easy threshold to meet. In this instance, I think it's a very easy threshold to meet, that the cost of services are X, the cost of upkeeping the street is Y, the cost of upkeeping the sidewalk is Z, and in fact, $7,500 for the restaurants from the restaurants is only contributing some fraction toward that. Mm-hmm. Right. And I just don't think the city would have any problem. I mean, in fact, as I was arguing sort of at the very beginning, in fact, the city subsidizes lots of things that we don't pay full price for. Right. So cities have a lot of leeway in terms of thinking about licensing, thinking about fees that I just don't think that the threshold of rationality is not one that's hard to meet, and I wouldn't worry about it here. Now, does it feel punitive? Sure, I'm sure it does. Does that mean it is punitive? I'm not sure. Even if it was punitive, even if that was the goal, the city has a lot of leeway, at least as a matter of law, to be punitive, right? Think about how the city and the state restrict access to liquor licenses, right? You could argue that that's a totally punitive structure. It's very hard to get a liquor license. Who you are, who you know, all those things matter, right? That's all real.
Right.
But does that mean that the city's not allowed to restrict access to liquor licenses? No, they're allowed to.
Moving ahead to the protest issue. So Mayor Wu has been the recipient of a lot of folks protesting in front of her home, people who are upset about vaccine mandates and various things. My understanding is these people were, be in the street in front of her house early in the morning, protesting. And so an ordinance was passed with the city council. It was enacted into law by the mayor that, as I understand, curtails the hours in which those protests can occur. A lot of folks are upset about that. And, from what I understand, sort of thinking back to my con law class, you think, okay, well, this is a group of people exercising their First Amendment right to protest. They're on public property. I mean, this seems like the government, in this case, the municipality, the city of Boston, saying you can't exercise that right on public property if it's in front of private property between these hours. It seems like that could be a problem. Is it? Can you tell us more about that and what specifically this ordinance does?
So can I predict with absolute certainty that a court will say that it's not a problem? No. Mm-hmm. Can I tell you what the cases have said in the past? Yes. And the answer is it doesn't seem very problematic. It seems like it's actually been drawn, the ordinance has been drawn quite carefully looking at prior precedent to avoid any problems under prior precedent. So there's a distinction, right, between banning speech in public spaces and restrictions on time, place, and manner of speech and protest. And the court has, generally speaking, been quite permissive about restrictions on time, place, and manner. So, in Illinois, for instance, there's no protesting outside people's homes. Even if you're on public property, you can't protest on outside people's homes. Think about if you want to have a march, you have to get a permit, right? There's all sorts of ways in which it's not true that you get to say whatever you want, whenever you want. What the city can't do is say, you may not say these things because you're saying things we don't like. And they can't say, you may not say them at all. Mm-hmm. So in fact, by restricting it from 9 to 9, I think is what the ordinance says, they're allowing for speech to happen. They're not restricting it based on its content, but they are restricting it in sort of like they're restricting the time, place, and manner as a sort of public safety, police power framework. And as I say, can I predict to you with certainty that a court would not find that problematic? No, because you're right. There are First Amendment feelings involved here. Mm-hmm. But just in terms of what the case law says and how this operates within the sort of constitutional framework, it's not problematic on its face. In fact, it's clearly been written by lawyers who've read the cases carefully to make it not problematic on its face.
Could you not argue that while not directly banning the manner of or what they're talking about, what the protest is about, that they are kind of indirectly curtailing protest against stuff the city wouldn't be, the city doesn't agree with, because the only people who are protesting in front of Mayor Wu's house are people who are adversarial to Mayor Wu.
Right, and so there's definitely a flavor of that, right, and that will always be true with any time, place, and manner restriction. So anytime anybody passes a restriction on protest, it's the people in power passing the restriction on protest, right, and they're the ones who would be subject to the protest. So there's always going to be a flavor of that, right? And here we've got there's a particular group of people that are targeted by it who are saying something that is opposed. So you could argue, I'm saying if I was a lawyer, I would make this argument. I am a lawyer. If I was a lawyer for the protesters, I would make some version of this argument that really this is about targeting a certain kind of speech. It's just that's not how this has generally worked, right? Like that's not how the whole point of having a neutral, content neutral time, place, and manner restriction is that it says you may say what you want, but only within these boundaries, right? And as I say, whenever you've got somebody in power making such a restriction, they're restricting protest against them because they're the ones in power, and the protest will, by and large, be targeting them. So it's not unique in that sense, right? How else would it ever be, right? You can't imagine a situation where like somebody in power is restricting protest of people they like, right? You know, or you could imagine it, but by and large, that argument doesn't feel, at least in the current case law, doesn't feel like there's a lot of purchase. Again, you'd have to show that there's some kind of animus, some kind of bad action in the background. And I think Mayor Wu's been really open about what she's doing. She's saying, I have neighbors, and you can yell all you want, but just let us have 8 hours of sleep. That's basically what she's saying. And like, that's completely consistent with all sorts of other kinds of public health regulations that we see all across local governments. It doesn't feel like sort of extraordinary in that sense to me.
So going off of that point, I guess we can wrap up on this. If I'm the lawyer and I'm I'm representing folks who want to protest and they're upset about this, they're bent out of shape about it, and I want to sue the city, I want to argue this is unconstitutional. What could you do, and I guess what can't you do with the fact, as we've I think sort of somewhat tacitly and somewhat not so tacitly acknowledged here, that if this were not if the circumstances were different, if people were not protesting Mayor Wu, this ordinance would not have happened. I mean, this ordinance is very clear purpose, very clear reason why this happened is because I'm the mayor. I do not like these particular people protesting in front of my house. I mean, if these were people protesting, in a different time, place, and manner. Matter of fact, if these people were protesting, causes that were a little politically different. Maybe we're protesting, for any number of the things that in the last few years we've seen people protest about. In some cases, these protests have turned violent. There's a lot of different, over the last few years, different forms and causes that, have been the subject of these protests. And we didn't see an ordinance then, but we're seeing an ordinance enacted for a very specific cause at a very specific place, time, and manner from a very specific group of people who feel a very specific way. Is there anything to be made of that from a legal perspective, that you're just punishing us, but you're not really punishing anyone else? Or does that kind of fit comfortably within the case law?
Well, let me say a couple things. One is that sort of as a matter of broader constitutional law, it's absolutely not the case that there haven't been limits on protests post the Black Lives Matter protests. Right? In fact, in localities all across the country, there have been much more draconian limits on time, place, and manner of protest.
What about in Boston? Do we know?
Not in Boston,
Okay.
but I just want to point out as a matter
Right.
of constitutional law.
Okay.
Right. So like if we're looking broadly across the country, there have been in many localities, there have been much more draconian impositions on when you can protest and how. So that's just sort of like point A. Point B would be, I think if I was their lawyer, I would be arguing that she's singling somebody out, that this is actually content-based. I just don't see it. I think that as a matter, if you're just trying to understand what's going on here, yes, it's true that Mayor Wu is the people who are targeted by this are people who are protesting against her. I guess the question would be, if there were a group of people protesting climate change outside somebody's home, and she passed this law, would anybody be complaining? Right? Maybe different people would be complaining, I think that law would be uncontroversially, under the precedent, we would think of that as law as uncontroversial. So you'd have to make some argument that this law is being passed because she's being targeted. And I guess my argument is that doesn't feel like it's clear enough that this feels like a normal time, place, and manner restriction. And again, I would come back to what I said to Ali, like in fact, this is how these kinds of restrictions always happen. Like they happen because something's happening, and that something happening is something that the people who would like to restrict protests want to restrict, and by and large, that's been permitted. Now, we might have disagreements about what the permissible realms of protest are, and so I actually am much more of a libertarian in that sense. I think people should have the right to make people uncomfortable. I just, as an answer to the constitutional question, I think that's an easier answer. And then we have a different moral question, different political question about what forms of protest we want to valorize. I mean, I said one more thing, is that some of this is coming because of a kind of anger. There's a lot of anger, right? And the question that we should all be asking ourselves is, how should that anger be expressed? And what is the civic space for that expression of anger? Mm-hmm. And I think the question that I would be asking on that level is, has Mayor Wu restricted the civic space for that anger in any way that really feels like problematic? Mm-hmm. And I would say no, right? Because that anger is something that can still be expressed within the time that's been allowed, but also it's not obvious that screaming outside somebody's house is the sort of anger, the sort of political discourse that we should be valorizing just flatly. We should be asking for ways to bring that anger into our civic discourse, into our conversations about who we should be and how we should govern ourselves. Mm-hmm. And kind of trolling as a mode of protest, it's not that it's ineffective, it's not that it's not powerful, it's just that we do want to make distinctions about how we create civic spaces for people to express themselves. And we always do that. That's what regulation is always doing that, mm-hmm. right? And so this is just a version of that. You might disagree with it in terms of its details, but I think if we're asking that question, we're having a different conversation mm-hmm. about what kind of civic space we want to have, what kind of civic space we want to prioritize and value.
Mm-hmm. Ali, you want the last word, brother?
Yeah, just to kind of follow up on that. Maybe this is more of a point than a question, but it is interesting because it seems like there's this tension between, I would argue that protesting in front of the mayor's house is probably one of the most effective ways to get your point across, as opposed to, just protesting, standing up in Boston Common and screaming whatever you want to scream. And so I think it's an interesting tension between sort of, obviously the state can curtail the most effective forms, the loudest, most explosive forms of protest, but, should they? And I understand that the argument that, she has neighbors and this is a nuisance is very valid, but I do think that tension is interesting.
Well, I totally agree. I mean, look, it is effective. Not everything that's effective is legal. Mm-hmm. And we don't actually live in a world where the First Amendment is that fully protective, right? We might argue that we should. Right. But if that were true, then many things for instance, we don't think of it as problematic to say that it's a criminal act to join hands across a freeway. But I mean, why? Right. That's because of a certain way of thinking about public space and regulating the highways. And it goes back to what we were talking about earlier about actually we treat roads as an entitlement as opposed to a service that are provided. So there's all sorts of ways in which forms of protest, some are okay, some are not okay. And we delegate the question of that to government. Right. And I guess this just feels within that. This is within that. Mm-hmm. So we can disagree about what that should look like. But I don't think it's constitutional, at least under the current doctrine, that it's a constitutionalized disagreement. It's a disagreement about where we think we should prioritize things. And my own intuition is, while it is effective, I'm not sure what it's effective for. Right. So what is the strategy here? Yeah. It seems to be a strategy of trolling as opposed to a strategy of building power, making change. And I'm not sure that politics by trolling is the way that we're going to move this country out of this kind of anger structure. So my own view is that I'm not hugely in support of politics by trolling. I would like politics by power building, politics by influence.
I guess I just had one last question on that. And I'm not sure, and I want to be careful. I'm not sure if the mayor's used the word trolling, but I know there's been a relationship between the mayor and these people that's been a little bit challenging, to say the least. When we look at, if the mayor were to say, or officials were to to look at these folks and to frame it as trolling. Is that not a content-based assessment of what these people are doing? Because I feel like it's hard to. I mean, they're argue that they're protesting, and I'm sure other people look at it and say, "Well, these are trolls. These are social media." You know, there's. I guess where do you draw the line between where the content and then sort of the legal framework of time, manner, and place? Because it seems like either side can try to draw that line to where it suits them. How do you distinguish?
Well,
that?
I guess let's ask it this way. So, what is, and definitely the mayor's not using the word troll.
Yeah.
That's me using the word. What is the when one is protesting at 2 a.m. loudly outside of somebody's home, over and over again, is that, like, when we call it protest, but there are different forms of protest, right? There are different ways of speaking, different ways of engaging, different ways of building power, creating influence. The reason why you're shouting outside someone's house at 2 a.m. is because it's 2 a.m. and it's annoying, right? That's the reason you're doing it, right? So that's why I'm not even calling them trolls. I'm saying that the strategy is a strategy of trolling. It's a strategy of annoying, of triggering, of channeling one's anger into making other people angry. It's not negotiation. It's not engagement. It's not even.
It's going to disrupt your sleep.
Yeah, right. And so I'm not even saying that's always unjustified. It could be justified, right? But I guess what I'm saying is as a matter of constitutional law, the state and local localities have always been able to control those sorts of things for nuisance reasons, for public health reasons. As a matter of, like, in an ideal world, what do we want our civic spaces to look like? How do we want to create space for people to engage with each other? My suggestion is that feels like, it's like there's a difference between if you're online and you say something and someone responds to you by trying to trigger you. That's what we call trolling, right? And this feels to me in that genre, as opposed to in a genre of productive negotiation, even righteous outrage. It feels like trolling more than it feels like engagement, I guess, is my point. Now, again, that doesn't have any constitutional significance. You couldn't ban them from trolling. You can't ban people from trolling. It doesn't matter whether they're being totally polite. You could still say you can't be there from 9 to 9 as a matter of constitutional law. I'm making a different point, which is to say, how do we create civic space that doesn't prioritize protest by trolling and prioritizes a sort of some kind of engagement where we can get somewhere with each other. And I take the point that people should be allowed to speak, and they absolutely should. There's a separate point, which is, how can we be thinking about creating spaces where people can speak to each other and be heard? Because ultimately, when you're shouting outside someone's window at 2 a.m, you're being heard, but it's precisely you're being heard in a way that guarantees that what you say will not be valued.
Right. All right, well, a lot of really interesting, political and legal and social dynamics we'll have to continue to pay attention to with respect to both these issues. This has been the BC Law Just Law podcast. We've been joined by Professor Farbman today. I'm Tom Blakely with Ali Shafi. It's been a great conversation, Professor. Thank you for joining us.
My pleasure.
All right, until next time, that'll do it. We'll see you again soon.